Mr. Smith, good morning.
Good morning. May it please the Court. My name is Attorney Mark Smith. I'm here with David Cherney on behalf of Aman Vakil, who has sought further appellate review before this Court on a decision of the Appeals Court. We are seeking to have the decision of the trial court upheld. We are here on two very narrow issues before the court. The appeals court found that denying the wife's motion to amend her answer in this particular divorce case and to be relieved of a stipulation regarding the enforceability of the parties' prenuptial agreement was error. To give you a little bit of background.
Could I ask you a question
Yes.
to begin with? And it's just, and it may be wrongly addressed to you, but if there's something that I just don't understand, and I must be missing something. If her motion to amend were allowed, then she would not be contesting the divorce. And then the provision of the antinuptial agreement would come into effect that since she isn't contesting the divorce, she would get alimony. Am I right so far?
She could make an application for
Right,
alimony.
right.
That's correct.
She could seek alimony. So then, why, if her motion to amend were allowed, why would she still want to be relieved from the stipulation? Is there something in the stipulation besides that interim clause, if you want to call it, or whatever you want to call it? Is there something else in there that the wife was contesting?
No.
So why, if her motion to amend were allowed, why would she want to withdraw her stipulation?
I don't know, Your Honor. And that's one of the problems.
Well, I think the sequence is that she first moved to withdraw the stipulation on the day the trial was to start, and only when that was denied, she then moved to amend the complaint.
That's right. And if you remember, when she filed, when Dr. Vakil filed the complaint for divorce, she filed an answer contesting the divorce, asking that it be dismissed. And then later on, she filed the stipulation saying that the prenuptial agreement that the parties had entered should be enforceable. And keep in mind...
I understand that, but what I don't understand about that is that stipulation, which was, I guess, in April or thereabouts?
That's correct. On just about the day the trial, the bifurcated trial on the prenuptial agreement
was to begin. Why did the stipulation... what should we make of the fact that the stipulation preserved alimony for the question of alimony for trial? I mean, what do we make of that? It sounds to me like the parties agreed that alimony was still an issue to be contested, litigated, resolved.
If you look at the transcript of the pretrial conference, there was a discussion back and forth between counsel and the judge about the terms of the prenuptial agreement. And the judge commented at that point in time the fact that the stipulation had now been entered as a temporary order of the court, that the question of alimony would rest on the interpretation of the prenuptial agreement. And it was later on at the trial, after the wife had spent a great deal of time challenging the husband on the divorce, that the court said that, in terms of his interpretation of the agreement, clearly she was challenging it, and under the terms of this prenuptial agreement, therefore, she was not entitled to seek alimony.
Do you interpret the prenuptial agreement as prohibiting challenge not only to the seeking a divorce at all, but also to custody, all the issues that might be litigated in a divorce proceeding?
Well, first of all, the prenuptial agreement that they entered into had some provisions about custody in it, which you may have seen. As practitioners, we know that those issues are left to the court at the time of the divorce. So clearly that was open to the court to determine at the time of the divorce. No matter what the parties wrote in the agreement, that wasn't going to be enforceable.
Mr. Smith, can I just ask you this, just to follow up on that? Generally speaking, in a normal separation agreement, which becomes incorporated into the decree and therefore is enforceable by way of a court order, we focused on things like child custody and payments for, not alimony, what's the word? Child support. Thank you. It's early in the morning. Child support. Just so everybody understands that the court can take a fresh look at that. When it comes to prenuptial agreements, and when we've developed jurisprudence that says, it's got to be, fair at the time it's entered into and fair at the time, should we simply say that a stipulation which the parties agree will have the force of a court order, that cannot be looked at by the court independently? I know it would be new and somewhat different, but we've been very careful in the area of prenuptial agreements as opposed to separation agreements which provide for alimony and the division of marital assets and so on. Do you understand my question?
Well, I'm trying to understand whether you're saying should there be a separate hearing on the prenuptial agreement at the time? The parties enter into a stipulation saying it's enforceable, like, for example, we have on a separation agreement where the court is adopting that agreement as its own judgment.
Yes.
I can tell you that in the courts since DiMatteo and Austin,
Right.
which have greatly helped to streamline these cases, if the parties agree to the prenuptial agreement via a stipulation or it's not an issue, that typically does not occur. However, at the trial, if there is one, then you look to the interpretation of the agreement. What does the agreement mean?
Is
So
it-
I think
is
that's...
it your position?
Can I just
Sorry.
just to follow up, so that and you've understood my question precisely, so that if we were to say that that we don't just look to what the prenuptial agreement means in classic contract terms, but we also, even if the parties have stipulated, concerning that this is okay, that we don't look to see whether it was fair at the time of the divorce.
Well, I think if the parties stipulate and it's
Right.
entered as a temporary order, there are several assumptions that are then made that, yes,
No, I understand the
parties
assumptions. No,
fair-
I understand,
fair and
but
reasonable.
essentially the parties are asking to have the imprimatur of the court, namely you could then...
That's correct. And in this particular case, keep in mind that this judge was more familiar with this prenuptial agreement than probably
Sure.
99% of the judges are in cases around the Commonwealth.
One of the reasons that the judge gave for denying the wife's motion to amend was that there would have to be a mistrial, et cetera, et cetera. But this wasn't a jury. This was just, couldn't he just say, well, I'll ignore anything now that isn't relevant?
Well, it's interesting because I had this discussion with some of my partners about, does anybody remember the last time they saw a mistrial in a divorce? And they're few and far between. But I think what you have to look to here when 15A talks about allowing people to liberally amend, and Sharon versus Newton is quoted in the brief, the question is, this is after a full day of trial. And
Right, I understand. So maybe the husband would be prejudiced. I mean, that's what...
Clearly.
The judge didn't make any findings, did it, on this? Or did he, and it's just not...
the
in
judge,
record?
if you look at the judge's summary of decision, which is included in our brief, and read through, he gave a very careful and reasoned rationale for his decisions regarding the prenuptial agreement in this case. In fact, more so than many of the judges that I see, in some of the other decisions. This was a carefully thought out process, and he did not, I think, deny that motion without taking into account what it meant in this case. And the parties that had entered into this prenuptial agreement freely and voluntarily, and they had made agreements, and it didn't mean that certain other parts of the agreement, she had the ability to apply for alimony, but she had to do something to do that, and that was not to contest the granting of the divorce.
Mr. Smith, as to the fairness of the agreement, the appeals court said this: the only party who suffers from enforcement of the agreement is the wife. As a consequence of the judge's ruling on the motions and the judgment that ensued, the husband was freed of all obligation to contribute to the wife's support while being left with the property held in his name only, including title to the marital home and his investment accounts, as well as his weekly gross salary of $4,512. On the other hand, the wife, at 55 years of age and after a total of almost 20 years of marriage to the husband, during which he was abusive to her, was left with various household items, 3 Persian rugs, her jewelry, coverage under the husband's medical insurance policy, along with the obligation to reimburse him for any additional costs in the premiums, and et cetera. So how was that fair to the wife?
Well, I think if you look at the summary of decision, and on page 3 of it, the court talks about how these are 2 highly educated people, that they had been married before.
Right?
That they had looked at least from my client's perspective, he didn't want to go through another contested divorce like he had done before when they divided up their assets and came up with support. The only thing he said here was, let's just make sure that at the time there's a filing for a complaint for divorce that we don't go through a contested. You can apply for alimony and do that. We went through a year or so of, and the judge points out, motion hearings, status conference, pretrial conference, at great expense to Mr. Vakil. He was living in a hotel at the time, incurring expense.
Excuse me, Mr. Smith. Was it clear that the wife's counsel understood that she was contesting the divorce and what that would do in terms of the antenuptial agreement?
Well, I think the judge pointed out one of the interesting things in his decision. He highlighted the fact that she was represented by competent counsel.
Well, I understand
her attorney was the one who filed the answer.
But there seemed to be some difficulties between counsel and the client. At least that's how I read the record.
I think you read it correctly.
But can you help me out a little bit on that? Where was the crossover in the examination or in the questioning by the wife's lawyer that transformed it from, a Section 34 questioning into the merits? How did that happen?
I think that it wasn't clear as to what the strategy was at that point in time. The strategy had been changing since day one.
But isn't the conduct of the parties during the marriage one of the considerations under Section 34?
Under Section 34, correct.
So the lawyer could have been asking questions about the conduct of the marriage forever.
And could have been, and that was exactly what was, she was in fact challenging the granting of the divorce and challenging the divorce under the terms of that prenuptial agreement.
Is it apparent from the record that the questioning changed from Section 34 into a focus on the merits of the divorce itself?
I think according to the judge who was there, and we grant the discretion to him to look at the testimony and listen to it, he said and concluded that he listened to that first day of testimony. And if you look at that transcript, he said, yes, there was a third or a half of the questions were devoted to contesting the divorce.
Was there any advance warning that the judge was telegraphing that he was getting this impression from the questioning that it was jeopardizing the stipulation?
I think that a couple times during the colloquy between counsel on that first day of trial, there was such an indication, particularly when they were talking about alimony, and the judge said, look at, this is challenging the agreement, and therefore, alimony is not going to be an issue.
I may be naive, but how do you challenge a divorce these days? I thought, we're a no-fault divorce, and
you're entitled to a divorce. That's correct, whether the other side challenges or not.
So what is behind the notion of, quote, contesting a divorce?
Well, I think that it said indirectly or directly the granting of a divorce. And I think in this particular case it was very clear that since the parties had been through this prior divorce with some acrimony for approximately 10 years of marriage, that when they entered into this one, for whatever the reasons are, and I've been doing this for a long time, and I stopped trying to figure out what those reasons are. They're human. That's
and
absolutely
they put that
correct.
provision in there.
That's right.
So when the judge says, or you say, he spent the half of the first day contesting the divorce, what does that mean?
What does it mean?
Well, I think it's just like what you would find in an inter rerum clause in a will. There's certain things that
but it's
somebody
meaningless.
does.
It's
well,
meaningless.
it is not meaningless in the context of this case when you look what he then went through for the period of a year while the different strategies were addressed.
I mean, you could spend 3 weeks, quote, contesting the divorce, and at the end, the party who wants the divorce is still going to get it under our state of the law.
Well, one of the things is that available to Mrs. Vakil at the time was the ability, according to Standing Order 299, to file a motion for relief from her stipulation that she entered into. But that never happened.
She was seeking that, wasn't she? I mean, she
No, there
wanted
was
to
an- there
amend
wa-
the answer, and
Well, the stipulation, there was an oral motion, but there was nothing ever preserved for the appellate court. There was never anything filed.
I know your time's over. Can I ask you one more thing? I'm
Yes.
sure the answer is going to be that it can't be done, but have the parties exhausted all means of settling this case? I mean, they're going to spend all their assets litigating this forever.
Well, and Judge, if you read the transcripts, there's no secret about the settlement discussions. They're in the transcripts.
Oh,
And
they
at
are?
one point, Dr. Vakil had offered alimony to settle the case. But, you know, as we find out when we go to trial, you know, there are offers and settlement made, and sometimes on the advice of counsel we take them, and sometimes we don't. And then we
all
live
right.
with our decision when we put our
Still
trust
not-
in the hands of a
Still
judge.
not too late.
I have two procedural questions, if I may.
Sure.
First of all, the party, or maybe you, I forget which one, refers to an amendment to the decision, and I'm not familiar with that procedure. I think one of the briefs says the judge in the probate court filed something with the appeals court, and the appeals court amended its decision.
Yeah, there were a couple of mistakes in the appellate court decision. One was that there was no disclosure attached to
Financial
the...
statements.
That's right,
But
and that
so
was...
the judge actually filed
The
something?
judge actually filed a memorandum stating that for some reason the transcript of the pretrial conference, there was the order from the pretrial conference was included, but there was some question whether there was in fact a recorded proceeding of the
Okay,
pretrial
and the
conference.
judge actually filed
And that's
it.
what the
It was
judge
very
clarified.
strange. I just didn't
Oh,
understand.
and is that what provoked the amended decision?
Yes.
Yes,
It was for the trial judge's memo.
that and also our
Application.
application.
And
yes.
my second question is, you just referred me to the judge's memorandum of decision to find his, when I asked you the question about did he make any findings of fact on why he denied the motion to amend, could you point me exactly
Sure.
what you mean?
On page 3 of that decision, first of all, you'll see a discussion of the antenuptial agreement, then alimony. And on page 3, it says the court, it goes on to find the court finds credible. And then it talks about them being highly educated people. There have been multiple court appearances in advance of trial. There are times when substantive decisions made that they cannot be undone without literally starting the trial over. I think you'll find that
Yeah,
in there.
but those aren't findings of fact on exactly why he denied it. I mean, that's going back again. You'd have to start the trial again, which I don't understand, because since it's a jury way trial, a judge can say, I'll ignore whatever is not relevant now. We'll go on from here.
I don't think you could do that in this case with all the pleadings that had been filed and
Well,
the
but that's
status
a
of the
different
case.
question. That's prejudice to the husband.
That's true.
But that's a totally different question from what he says about mistrial and all the waste of time. I mean, people settle all the time in the middle of trial, or settle one issue and it's removed, and no judge that I know complains when something gets settled.
But one of the biggest problems here was Dr. Vakil had an opportunity at that bifurcated trial on the prenuptial agreement to put in his case that, in fact, the agreement was enforceable. He was denied that right when she agreed to stipulate to its enforceability.
But then couldn't he be relieved
Yeah.
of that? I mean, with a jury
Can have a
trial,
hearing
it's so
about it.
flexible. The judge can do whatever he or she wants.
Well, I think that you would create pandemonium in the probate and family court if we don't have people enter into stipulations, temporary orders are made, there are standing orders that provide a procedure from being relieved from those, and if we now say that after a day of trial, one can simply undo things that have been done, I think that you're inviting all kinds of
I
problems.
asked about the judge's findings. If he had made some findings, that he could say things like that.
Well, I think that he
didn't.
again, there wasn't a hearing on the prenuptial agreement, so he didn't have to make findings with regard to the prenuptial agreement. That stood on its own as a contract between the parties. He did make
but she's-
findings regarding the divorce.
But she's asking to be relieved from all sorts of things, and he's denying that, and we need to know why.
I don't think that he could have said it clearer than he did in his, I was quite impressed with his summary of decision.
Okay, thank you.
Thank you.
Thank you, Mr. Smith. Ms. Ajami Vakil? Before you begin, let me just explain you probably have worked this out, but you have 15 minutes.
Yes, Mr.
Then
Land
it'll
explained.
go down in time. When you've got 1 minute left, the yellow light will start flashing, and then when the red light starts flashing, would you please end your argument? If there are additional questions, as there were to Mr. Smith, of course you can answer those.
Thank you.
Good morning.
Good morning, Madam Chief Justice and Associate. My name is Geeti Ajami Vakil, and I represent myself. There are several issues that I would like to address the court today, if I may.
You may.
I signed this prenuptial agreement knowing that I was giving up my financial right for the sole reason protecting my son.
Did you have a lawyer at the time?
Yes,
So you had legal counsel?
yes,
So you fully understood the agreement?
yes. But also in the record, it's a letter from a lawyer that he advised me that it's page, I believe it's one of the page in the record,
Appendix, yeah.
that if I quote from his recommendation letter to me, if I quote to the court, please.
If it's in evidence, yes.
Yes. In regard to the separation agreement, no, this is the first letter from first divorce, second one, prenuptial. I'm writing to you also to again express my disappointment and outright disapproval of the antenuptial agreement you signed, and it's based on your marriage to Dr. Vakil. I fully understand that your ulterior motive was Arshia happiness, your son. However, from a legal standpoint of the view, antenuptial agreement you signed was certainly not in your best interest. I'm particularly concerned that you waive past child support and alimony owed to you. It appears to me, based on the very recent financial statement supplied by Dr. Vakil, that are no real basis for the substantial reduction we ultimately took the payment of their child support and alimony over the past several years.
So why did you agree to it?
The reason I did for protecting my son, because my husband threatened me, if you don't sign this prenuptial, I take your son to Iran. And my son was born here, I want to raise him here, and I was aware of what I'm giving up. But I did because I didn't have any choice.
Can I ask you then, let's go forward to April of 2003, when at the time that you entered into the stipulation agreeing that the antenuptial agreement was
Yes.
enforceable or valid. You were represented by a lawyer then.
Yes.
Why is it that, I shouldn't ask you directly, it's almost asking a cross-examination question, but so what occurred then that caused you to enter that agreement? Again, knowing
The
that...
stipulation.
The stipulation.
That
What caused you to enter the stipulation, saying that you agreed the agreement was valid?
Still, I'm happy to have the prenuptial agreement, everything in the prenuptial agreement. I knew that I'm giving up. I did for my son, and I respect the prenuptial agreement. If the judge said that they have to have first look and second look, that was the system, that was the justice. But I signed the prenuptial agreement for my son, and this is my sacrifice, and I respect that.
Why did you try to withdraw the stipulation, take it back?
My lawyer told me that sign this, and I did. But the truth behind everything, that I did sign this prenuptial for my son, and it's very interesting because before 25 years, when I married with my husband, we had the same lifestyle. We were not coming from different lifestyle. I had my job, my house, my money, everything. And I brought everything to this marriage. It's not that I want his money. Everything I had disappeared through these 25 years for me to protect my son and leave peace environment for him. And that's the reality of this
How old is your
case.
son now?
21.
And he's in this country?
Yes.
So he's emancipated. He can't be taken back to Iran or anything else.
No. But Your Honor,
So that whole part of the thing is moot.
yes, and Your Honor, if I address to the court,
Wait, could I ask you one question? I'm sorry. The only part of the prenuptial agreement that you were contesting was the alimony provision. That's the only part about the waiver of alimony if you contest the divorce.
I didn't contest the
And
divorce.
to this day, you don't. Okay.
I never
No, forget. You didn't contest the divorce. Okay. But
I take
let,
it-
let me ask this another way. Is the only part of the prenuptial agreement that you're concerned with the part that says no alimony if you
Yes.
do contest the divorce? That's
Yes.
the only part you're concerned
Yes.
with.
I
Okay.
want this prenuptial, everything that is in prenuptial. If it's not fair or unfair, that's not my job. I never want to leave. I never said or wanted to stay in this marriage. How
So
can I
What do
do
you want now? What do you want now?
prenuptial agreement with everything on it?
You're unhappy with the judge's decision
Yes.
where he says, you contested the divorce and I'm not going to give you alimony. That's
Yes.
what you're unhappy with.
Yes. And I didn't contest the divorce. How can I contest this divorce? As Your Honor mentioned, he was convicted in the Commonwealth by threat to commit crime towards me. How could I live with this man? I renew my restraining order for more than 2 years. How could I want to live with this man? And that's my point.
So the only thing you're looking for now is alimony, period.
Alimony, lives,
You're looking for the terms of the anti-nuptial
Yes.
agreement.
yes, Your Honor.
But,
No,
okay.
you want to live with the term. You're happy
Yes.
with the term.
Yes.
Right.
Yeah. So you're happy with the terms of everything in that agreement entirely, except for alimony. You
Well-
want alimony.
Judge ignored, Your Honor, judge ignored the fact that it was alimony, health insurance, and life insurance, and
In the-
$25,000.
In the anti-nuptial agreement provides for alimony.
Right.
Well, it provides she can seek it.
You
Yes.
can seek it.
Yes,
Speak it.
And the judge said that he's not going to give you alimony because you contested the divorce.
Correct.
yes,
So if you and your husband enter an agreement as to alimony between yourselves, that's the end of the case. Am I
yes.
correct?
Alimony and $25,000 and life insurance.
Right.
Everything in prenuptial agreement.
Well, that's,
Yes.
most of
Okay.
that isn't in dispute except for the
But
alimony.
he ignored all of the other part of
Yeah,
the prenuptial
The
agreement.
judge didn't order the $25,000.
No, and he didn't-
$6,000 moving expense, but no $25,000.
And he didn't order the life insurance.
Mrs. Ajami Vakil, let me ask you this question. I understand your position that you have not contested the divorce. What was your understanding as to what the purpose of all of the pre-trial proceedings, the motions that were filed, the various, what was your understanding as to what was happening?
Yes, Your Honor. Before Judge Sachs, I had another judge, Judge Reinert. My ex-husband, in August, asked me to leave the home, to leave the marital house. They took to the judge Reinert. He didn't order me to go out of the house. I don't know because of, at the time, my son was there or whatever. At the time, he didn't order that I have to leave the house and get the $25,000. So the pretrial was for alimony, was for $25,000, and was for everything. And it's so interesting, Your Honor, that even Judge Sachs, after my testimony, he said, I have to look at the alimony. And he told his lawyer, my ex-husband lawyer, look at the last alimony. Look at the previous alimony. And I don't know, judge penalized me for the testimony, the cross-examination of my ex-husband lawyer with my husband. That was the only thing judge penalized me, because I never said I want to live with him. They asked me this question.
It's, I'm sorry.
So
But
I didn't
take-
contest
So
the
what you're really looking for is enforcement of that stipulation, which means that you need to go back to court because the judge is going to set the amount of alimony. Is that right?
Yes.
I mean, it's not that it has been set already.
No, it's not.
So,
And
that's what you're looking to do.
Do you
Yes.
work? Do you work?
yes, something else I want to tell you. Through all the marriage, it's not that I worked.
What is your job at this time?
I'm a teacher in Catholic school.
Okay.
This is Ajami Vakil. If we look at, which we will, at the whole record, whether in the papers that have been filed or the transcript of the hearing of the trial, will we find no suggestion that you were challenging the granting of a divorce? Is that your position, that you never challenged the granting?
Never.
But
No,
what about your complaint that the lawyer filed? Didn't it say something about that you were challenging the divorce?
Your Honor, the answer was filed while ago, before
I'm sorry,
any
your
of these
answer.
pre-trial and trial. If the judge knew this answer, it means contesting the divorce. Why he mentioned over and over for pre-trial, for trial, alimony. Alimony was the case. Always. I don't know what happened that at the end, he said that I contested divorce. The reality is I didn't want to stay in this marriage. And it's very obvious.
Is there a statement in the record of what your income is? I assume there is.
Income?
Yes.
Yes,
there is.
500 something a week. And
So you, as a teacher in a Catholic school, which common experience indicates pays much below public schools, you're making about $25,000 a year.
30.
Your husband is making
28,000?
30.
Your husband is making 200,000. Am I right?
280.
280,000.
And if I add, Your Honor, at the time of the prenuptial, I sacrificed everything. He owed me about 200,000 child support alimony, my money, everything. I give up everything, but I said I'm going to have a modest income with my income from the school system and alimony because he's a doctor, so I'm eligible to have health insurance. So I sacrificed everything for the safety and best interest of my son, and I was aware of that for financial situation. But even everything I give up, it wasn't enough for him. He didn't want even respect this prenuptial agreement.
But if we were to say that whatever we do, if we were to say that there's no need in further proceedings to consider the validity of the prenuptial agreement, you would be content with that because you say that
Yes.
that the agreement is valid.
May I add something? Because, on the other hand, I never have the resource. I owe hundreds of thousands of dollars for legal fee. I owe to all the people around me. And even if you say this prenuptial is not valid, I don't have a resource to go to the court. And I know that he transferred all his money out of country. So it's no good for me. I cannot hire a lawyer because he took everything I had, not everything we had. He has everything from my side of family. It's not only his money that he took, everything. And it's not, I was the only one care of for my son, but also I contribute with my money to this life. It's not that I was sitting as a doctor's wife and just take care of my son. No, I did everything for this marriage.
In the first divorce, there was a separation of property, right?
No,
I
That's,
thought you got the house in the first divorce.
But
But-
you continued to live together, didn't you?
but, yes, Your Honor, but it wasn't. That's my letter to you, that it wasn't any. The reason is, I have another, if I may quote from my lawyer first separation.
Let me just suggest this. You've only got a few seconds, and if that letter from which you were quoting is in the record, we
Yes, it
will
is.
have an opportunity to read it.
Okay.
Do you have the page where it is in the record, or just tell me
We'll find it.
what the date is?
In the letter that I gave it to Ms. Mellon to the court, it mentioned
Okay,
the first,
that's fine.
so it's there, the letter to you, that it wasn't settlement, it wasn't division of the property, nothing like that. It was $5,000 child support and alimony, and again, we were living together. And if you look at my prenuptial agreement, everything I wanted, just he doesn't take my son to Iran. Everything on the first, he give up Commonwealth, doesn't allow full custody. But I gave up every financial situation to sake of my son. And I'm proud of this, and
But
I don't
after-
complain.
As a result of the first divorce, either because of an agreement or because of a judge's order, did you get the house?
No, I didn't. I agree, because
But did the judge order that the house be transferred to you?
we settle out of the court.
Whose name is the house in?
Always his. Always was his. Always everything under his name, even if I contribute money to that.
That issue is not before us, correct?
Right.
I think so.
The ownership of the house, that's not part of what this case is about now, correct?
I don't understand, Your Honor.
Okay.
your
The
question.
ownership of the house is not involved in this appeal.
No.
No, he sold already the house. Everything is.
Okay.
Thank
Thank
you,
you.
Mr. Jami Vakil.
Thank you very much, Your Honor.